Division M, this is review. This is the one where it says that the CPS, parole, hospital, DA, law enforcement agency shall forward relevant information pertaining to a sex offender to be discharged, paroled no later than 120 days prior to the discharge or release. And the board shall make recommendations within 60 days. Upon application of the sex offender or the DA, the court shall seal any portion of the file pertaining to the offender that contains confidential material. However, that in any subsequent proceedings, such sealed record shall be provided to the offender, the DA, the court, and the Attorney General, where the Attorney General is a party or represents a party in the proceeding. Okay, so now remember, this was 120 days for CPS and the hospital and everything to send information to the division. Now, it says a determination that an offender is a predator, violent, or predicate, or the level and time of their, designation has to be done by hearing. Both determinations of the sentencing court shall be made 30 calendar days prior to discharge, parole, or release. No later than 30 days prior to the board's recommendation, the person shall be notified the case is under review and that they're permitted to submit relevant information. Where a finding was previously made, the court shall assign counsel to represent the offender pursuant to Article 18b. At least 20 days prior to the determination proceeding, the sentencing court shall notify the DA, the offender, and his attorney or her attorney in writing of the date of the determination hearing, they're calling it the proceeding now, and shall provide the DA, offender, and counsel with a report, copy of the recommendation received from the board, and any statement of the reasons for the recommendation. Then it has to include the notice about what it's for. It has to include a returnable form in case you need private counsel assigned, 18b. If the DA seeks a different determination than what's submitted by the board, at least 10 calendar days prior, they shall submit to the court and to the offender a statement setting forth the determinations sought by the DA and the reasons for seeking them. The court shall allow the offender to appear and be heard. The state shall appear by the DA or his designee, who shall bear the burden by clear and convincing. Materials may be obtained by subpoena if not voluntarily provided to the requesting party. In making determinations, the court shall review the victim's statement and any relevant materials and evidence submitted by the offender and the DA and the recommendation of any materials submitted by the board, and may consider reliable hearsay evidence submitted by either party, provided that it's relevant. Facts proved at trial don't get re-litigated. If the repeat, basically, if it's high, they get a 3. If it's moderate, they get a 2. And if it's low, they get a 1. Okay. And they also have to classify them as predator, violent, or predicate if applicable. Okay. So this says the appellate, upon reversal of conviction of a sex offense, the appellate court shall remand the case to the lower court for entry of an order directing expungement of any records required to be kept herein. So, if it's reversed on appeal, there's going to be an expungement of the records. But for some reason, the appellate court doesn't do that themselves. They remit it to get done by the sentencing court. So the thing that I'm totally confused about here is that this has a 20 days prior rule. The sentencing court shall notify them 20 days prior to the determination proceeding, but I'm almost positive that before I read something that said it was 30 days. Okay. Anyway. Oh, petition for relief from modification. So the people that can do this is someone who's a level 2 who has not been designated a predator, violent, or predicate and has been registered for a minimum period of 30 years. They can make an application, okay? Such a petition shall not be considered more than once every 2 years. So again, this is a petition for the duration, to something about the duration. Okay, and this can only be looked at every 2 years. Such a petition shall not be considered more than once every 2 years. The DA can appeal as of right. Then 2 says that they can make anyone required to register or verify. So anyone can make a petition for an order modifying the level of notification. And that can't be considered more than annually. The offender shall bear the burden of proving the facts supporting the requested modification by clear and convincing evidence. Same rules about 18B. The DA may file a petition to modify the level. So I'm assuming that means make it go higher. If the person got like a rearrested or a repeat offense, the petition shall set forth the level of notification sought and the reasons seeking the determination. The offender can appeal of right if the petition is granted. So we have 3 petitions here. We have one that's by a level 2 who's not a violent predicate or predator, and that can only be done after he's been registered for 30 years. And that would be a petition regarding the duration. Then we have another petition that can be made by anybody regarding the level of notification. Then the third petition is one by the DA to modify, I guess, upwardly. And the petition, it's basically based on a new crime or a violation of the conditions of sentence. The conduct underlying the new crime or violation is in nature that indicates an increased risk of a repeat offense. Upon receipt of a petition, the court shall forward a copy of the petition to the board and request an updated recommendation, and shall forward a copy of the petition to the other party. The person has the right to be represented by counsel once they make this petition. Filed by a DA at least 30 days prior to making the updated recommendation. The board shall notify the offender and their counsel that the case is under review. After receiving an updated recommendation, the court shall, at least 30 days prior to ruling, notify them of the hearing date. The court may consult with the victim. The court may grant or deny the petition. If it's granted, it shall be the obligation of the court to submit a copy of its order to the division. Upon application of a party, the court shall seal what's confidential. All right, then this P thing is talking about a special phone number, and it has to have a preamble that call recorded, no charge, identify themselves, current address, required to be 18, illegal to use the information, birthday, license or identification number of the person they're inquiring about, not a crime hotline, a statement that an information package will include a description of the law and sex abuse abduction prevention materials is available upon request. Such information shall include questions and answers to the most commonly asked questions. 2-A, the division shall establish a program allowing nonprofit and not-for-profit youth services to pre-register. A pre-registered certificate shall be valid for 2 years unless previously or earlier revoked. No fee shall be charged for an application for a pre-registered certificate. Notwithstanding any per-call limit the division may place on calls, the division shall allow pre-registered organizations to inquire about up to 20 prospective coaches, leaders, or volunteers. And that means it's a formalized program with adult-supervised sporting activities. Or match children with adult volunteers to have positive role models. This charger's fucked. Okay, then it says the division shall maintain a program allowing a transportation network company, TNC, pursuant to the VTL, to submit electronically multiple names. The division shall respond to such inquiry electronically within 4 business days and notify the TNC of any such applicant who's listed on the registry pursuant to this article. Whenever there's reasonable cause to believe that any person or group of persons is engaged in a pattern of misuse of the phone number, the Attorney General or any DA or any person aggrieved by the misuse is authorized to bring a civil action in the appropriate court requesting preventative relief, including an application for a permanent or temporary injunction. restraining order or other order against the person or group of persons responsible for the pattern of misuse. The foregoing remedy shall be independent of another remedy. They can get a fine of not less than $500 nor more than $1,000. Division shall submit to the legislator an annual report on the operation of the phone number. It shall include but not be limited to A, number of calls, D, detailed outline of the money expended, C, number of calls that resulted in affirmative response and the number in his negative response, D, number of persons listed, and E, summary of the success of the phone number based upon selected factors. Okay, then internet posting. Division shall maintain a subdirectory of level 2 and level 3. Type of victim targeted, name and address of institution of higher learning, all the conditions, all that gets posted. So email notification is, okay, the division shall furnish a service to no charge to the person, I guess, looking for it. Email notification is limited to 3 geographic areas per email account. If you abuse this, it could be a fine of $500 to $1,000. Unauthorized removal of duplication or duplication from the offices of a police department shall be punishable by a fine not to exceed $1,000. In addition, the AG, DA, or any other person aggrieved can bring a civil action, blah, blah, blah. Same thing, immunity from liability unless it's shown that the official, employee, or agency acted with gross negligence or in bad faith. The division shall, on or before February 1st of each year, file a report with the governor and the legislature detailing the program compliance, any recommendations to further enhance the intent. Failed to register penalty. Class E felony for the first offense, subsequent or second is Class D felony. Any offender who violates the provision in 160V, which is the ice cream truck, frozen dessert truck, is guilty of the Class A misdemeanor for the first offense, and upon conviction for a second or subsequent is a D felony. Can also be basis for revocation and probation. The U says the U for unauthorized. The unauthorized release of any information required by this article shall be a Class B misdemeanor.